CR1 is now in session.
Please be seated. Good morning. This is the time set for oral argument in EH Petitioner versus the Honorable Dan SLAYTON, Judge of the Superior Court for the County of Coconino. Jason CONLEE, real party and interest. Out of respect for counsel in the court, I ask you to make sure that your cell phones are turned off or any noise-making device is turned off or on vibrate. Each side has allocated 20 minutes for argument. Appellant, you may reserve a portion of that time for rebuttal if you wish to do so. You will need to keep track, both parties will need to keep track of their time using the podium clock. We have read your briefs. We conferenced this case this morning. We encourage you to keep that in mind when you do your oral arguments. We are pretty familiar with the record that you've presented. These proceedings are being recorded and will be posted to YouTube. Before you begin your argument, please state your name and the party you represent so that people watching on the internet will know what's going on. With that, counsel for appellant, you may proceed.
Good morning. May it please the court, Colleen Clace, Arizona Voice for Crime Victims, on behalf of crime victim EH. The disjunctive reading of 134401-19 that the state uses impermissibly narrows and excludes victims who the legislature intended to protect from asserting and enforcing victims' rights. Under the Victims' Bill of Rights, the legislature can act to preserve and protect, define, implement victims' rights. What they cannot do is narrow victims' rights, nor can they narrow the people to whom victims' rights are intended to assist. When the legislature expanded the constitutional definition of a victim to include grandparents and siblings, they did so recognizing the trauma and emotional impact that murder leaves behind on those left behind. To read this statute in the disjunctive violates a victim's right to due process. It leads to absurd results, and it's not construing the statute in harmony with the Victims' Bill of Rights and its implementing legislation. A victim has a constitutional right to justice and due process, and to be treated with fairness, respect, dignity, to be free from intimidation, harassment, and abuse.
Counsel.
Why is it necessarily an absurd result if it's not a murder? There's a victim of a very serious crime, and certainly that affects every family member. Yet in that instance, we don't have multiple victims. Is it necessarily absurd to read it that way when it's essentially in a case where where the person is not there to speak for themselves? We're essentially having someone who can represent their interests?
Thank you, Your Honor. Yes, it can be. For example, in a case where there are two elderly victims who were victimized by a child, and they ask another family member to assert and enforce their rights, those two elderly victims should not be denied their rights. They should still be able to refuse a defense interview, even though they have someone else that they've asked to assert and enforce their rights. It can lead to an absurd result and an end run around victims' rights.
I may have missed that. Were you saying there were two victims, or?
Your Honor, I'm giving you an example of when you had asked, if I'm understanding, when a victim who was not killed but decides to have a legal representative appointed to assert their rights when there would be absurd results. In this case, there was one homicide victim. The victim I represent is his sister.
And maybe I misunderstood Judge Catani's question, but hypothetically, let's assert not this crime, but a crime where a child victim is a victim of a serious aggravated assault that they're going to end up in a wheelchair for the rest of their life or something like that, where it's pretty horrible. In that case, although that's got serious and long-term lasting ramifications upon the family and all sorts of people, the statute and the Constitution don't make sisters or siblings victims in that case. So why would we ignore the language of the or statute in the victim's rights for this case, but not for those other cases?
And in that particular case, Your Honor, you are correct. That victim would still be living, and if they are able to assert rights, or under 134403, a parent or legal guardian can assert their rights on that. However, I'm asking that this court not read or not interpret the statute in the disjunctive, because there are a number of situations that could arise. And in the Knapp versus Martone case, the Arizona Supreme Court warned of limiting and excluding victims, and that could lead to hearings and other situations that we are in, like this case.
Let me ask the question I was going to ask.
Sure.
So we're in a special action posture right now, which means our first threshold is whether we accept jurisdiction, and that's kind of a different issue from the merits. So in reviewing the record, it does seem like we are very, to use probably an inappropriately colloquial term, late in the game for the rights to have been asserted at this point. Could you address that a little for us? And I realize that you only got involved, but DCS, which is an agency of the state, was aware of these criminal proceedings for a long time and never took anything in loco parentis did anything to assert victims' rights prior till your involvement, basically. So yes. Why is this an appropriate vehicle for us to exercise special action jurisdiction and clarify this area of the law?
Of course. First, I'll address the issue with why I'm getting involved at this point. Your Honor, when EH became a victim upon arrest and formal charging, there's a procedure in place by the Victims' Bill of Rights. And by under subsection A12 and ARS 134408, the state has an affirmative duty to inform victims of their rights, of the charges, and of the procedure on how to assert their rights.
And DCS, who's standing in the shoes of the parents at this point,
correct,
was aware that there was criminal proceedings going on and was aware that their rights, the rights, if there are rights for EH, weren't being followed, and waited years basically before deciding to say, hey, we're a victim. So why is this a good vehicle to take this case?
This is a good vehicle because there was a violation. DCS was not aware of the violation until after it happened.
How can you say that?
Because EH had a right to confer with the prosecution. EH or DCS acting on her behalf, they had a right to confer with the prosecution about the resolution of the case.
DCS was not aware of that right?
DCS, they are aware of the rights, but the affirmative duty is on the state to provide those rights and also to let DCS know the procedure for asserting those rights.
But let's say a victim didn't get a letter from the county, but absolutely knows the process. Would we, and had told people, I understand that I have the right to provide input, but I'm not going to do it right now, but maybe later I'll do it. Would we allow the victim to come in and try to undo something that's happened up to that point? If we could say for certain that the victim knew, and I think that's kind of what we're suggesting, that there's really no question that the DCS knew at that point. Would we say it's okay to come in and we're going to undo something that's happened up to that point?
It is my understanding, Your Honor, that there were folks that were involved in the case. First, DCS's function is not to provide representation to crime victims, but correct. They did know their function is to protect children. They were involved in the dependency proceedings. It's my understanding that there were representatives who were involved in those dependency proceedings that did communicate with the prosecutors at the county attorney's office.
Well, let's say they'd waited until we've gone all the way through the process and the court has imposed sentence, and then DCS comes in and says, well, the victim wasn't notified. We want you to undo the sentencing process. I mean, it leads to a different question on jeopardy. But
of course.
At some point, I mean, would we not say it doesn't really make sense to allow someone to come in and undo something that's already happened if they were essentially on notice, but didn't assert the rights earlier?
I don't think there's any prohibition from a victim or a victim representative not asserting rights in the beginning, but later on deciding that they do want to have a say.
I agree, and going forward, I would agree that the victim should be allowed to go forward. But if you're asking that something be undone, that seems to be a different question.
Of course, in the example you cited, if sentencing had already gone forward, I think we would be in a different procedural posture. Here, because sentencing hasn't gone forward yet, and there are other rights that could be at stake if this court rules that EH is not a victim or is not entitled to assert rights. There are 4 other defendants in this case whose cases have not been resolved yet. So there are rights that are at stake moving forward. Could
I ask you about the
sure.
Your briefing suggests that there's not any sort of double jeopardy implication, that jeopardy has not necessarily attached. What's your best case for the proposition that jeopardy has not attached to the plea, so to the charge itself? I understand that jeopardy hasn't attached to a sentencing decision, but why hasn't jeopardy already attached to the entry, the acceptance of the plea to the charge?
Of course, Your Honor. By the terms of the plea itself, which is Appendix 1 to my petition, Terms 12 and Term 6, the defendant has initialed provisions stating that the court at any time can reject this plea even after acceptance. By the very terms of that plea, which he signed and presumably his counsel discussed with him.
How far out does that go? When can the court can just change its mind? How far down the road?
I don't believe that the actual plea itself set a deadline for when the court can change its mind, but my assumption is that it would be before entry of judgment and sentence in this case.
If it has been accepted, it would seem to me the victim and the state would want to be absolutely certain that jeopardy had not attached, or you run the risk of, if you withdraw that plea, you run the risk of not being able to charge the defendant at all. So it seems to me that there's at least a pretty significant concern as to whether jeopardy has attached. And if it has attached, it doesn't seem like it would be in anyone, or certainly not in the victim's interest, to want to withdraw that plea.
Of course, and it is the victim's position that jeopardy has not attached. I don't believe the state had addressed jeopardy in their briefing. Even if this court, or even if you were to remand it back to the trial court for a finding of whether or not jeopardy attached, it's still important to address the issue of whether 13440119 should be read in the disjunctive, and whether that moving forward, even worst case scenario, if jeopardy has attached in this case, with this particular defendant moving forward, there are other rights at stake, and a violation of those rights. EH, essentially, in being denied due process, was denied the process that the Victims' Bill of Rights and the implementing legislation lays out. The process of first being informed of her rights, being informed of the process on how to assert her rights, being notified of a plea agreement, having the constitutional right to confer with the state.
Doesn't Rule 39 provide the only remedy for the violation of those rights is for a court to reconsider prior decisions that have been made already? So all we'd be doing if we did find victims' rights would be to tell the Superior Court, All right, now you have to reconsider whether or not you accept this plea.
Of course, Your Honor. The court and also ARS 134437A provides the remedy for a reexamination or reopening of a plea. I believe subsection B addresses reopening of a plea. And the court could make, direct the state to do that and direct the state to confer with EH on her views so that her rights to due process, fairness, respect, and dignity are upheld moving forward. The not reading 4401-19 in the disjunctive, reading it in the disjunctive provides an end around victims' rights.
Would you agree that, there's a lot of emphasis on constraining our review to the statutory text, and it's hard to read or as anything other than or. So give me your best argument for how I should be reading or to say and or.
Of course, Your Honor, you should be reading or as and or in this case because it would be in harmony with the Victims' Rights Act, the Victims' Bill of Rights and the implementing statutes, which were enacted to provide victims with a level of participation, respect, and protection throughout the process. Your Honors, if it's okay, I would like to reserve my remaining time for rebuttal.
Yeah.
Thank you.
Counsel, before you begin, are you going to be the only speaker for the real parties in interest, or are you dividing your time?
Your Honor, and I may be mistaken, my understanding was I thought we each had 20 minutes. I'm speaking for the Coconino County Attorney's Office.
No, it's 20 minutes per side.
Per side.
The real parties in interest get...
Judge, then I suppose we'll divide our time 10 minutes each. Okay.
I'm going to leave that up to you guys to enforce it, so you'll have to tell him to be quiet when his 10 minutes is up.
Absolutely, Judge. Thank you. Good morning. May it please the Court. My name is Michael Tunick. I'm here representing the Coconino County Attorney's Office. The Coconino County Attorney, Bill Ring, is here with me today. I want to start with some questions that the Court answered since my time is, or the Court asked since my time is limited. The Court asked Petitioner why it would not be an absurd result for, in the one of the three parts of 4401-19, for a victim who is surviving, for their family members not to be included. And I think that's a very astute question, and one that I brought up in the briefing, because when you look at the statute, of course we start with the premise that or means or. And so or means what it says it means. And the case law is clear that or means or. And even,
Wait, don't say that. Case law is clear. Point me to a case that says or means or.
Okay.
But even before doing that, if we just read this, if it said victim means you are either a parent, a spouse, or a child, doesn't that mean all three of those are victims? You are a victim if you are either a parent, a spouse, or a child.
Well, I think the statute reads, and sorry.
I'm sorry to distract you from finding a
sure,
case.
State v. Piotrkowski is one that I cited. When used in a statute, we give the term or the usual disjunctive meaning, expressing alternative choice among two or more things. When you read the statute, it is, sorry, let me find the text here. It's a three-part structure. The three parts are that a person against whom a crime is committed, a person who's incapacitated, or a person who is killed. And obviously the language on person who is incapacitated or killed is identical. And the wording specifically is a victim is a person who the crime has been committed against, or if the person is killed or incapacitated, the person's spouse, parent, child, grandparent, or sibling, any person related to the spouse by consanguinity or affinity, or any lawful representative of the person. And so I think that,
You skipped one word.
Apologies. lawful representative of the
No,
person.
no, no, it's before that, and I'm not sure that it matters, but I'm trying to parse this statute. It begins with, victim means a person against whom the criminal offense has been committed, including a minor, or if the person is killed or incapacitated, the person's spouse, grandparent. I read including as modifying all of that. Would you agree with that?
I would not. I read including as just including a minor, so that a minor could be the person whom the offense has been committed.
So why would the legislature need to say include a minor? That's covered with the offense against whom the offense, or the person against whom the offense is committed.
Okay. It's a good question, and I think that the reason
So
that I read
as
it,
I read it, we have including, and then the list of all these people, minors, or if the person is killed or incapacitated, spouse, parent. So I read it as including the person, spouse, parent, child, grandparent, or sibling, which sounds an awful lot like what Judge Catani was talking about, either including, and the statute in a different section of the ARS defines including as a term of inclusion for all of these statutes. So we have a situation here in which including all these following, which seems to be to say and or.
And I disagree partially because of the structure, because it is in a separate clause there delimited by commas, and partially because, again, zooming out just a little bit to the structure of the statute, if the concern and if the legislative intent were to include everyone who was affected by a criminal offense, then that would happen in all three instances.
But could I zoom out a little bit further to the most absurd result from my perspective? If we adopt your approach, let's say there are two parents who are divorced who don't get along at all. It seems to me under your approach, or grandparents, aunts and uncles, but let's just limit it to two parents. It seems to me under your approach, we have to have a trial or a hearing, an evidentiary hearing, on which one of those parents gets to be the victim in this case. And how would that type of proceeding in any way further the intent and purpose of the Victim's Bill of Rights? Why would we want litigation? Why wouldn't we just let both of them come in and present their points of view and let the court do with their points of view what it will?
I think I understand the court's point, and I think in most cases the court's point is well taken. I think in some cases there could be a serious reason to have that proceeding to determine which parent is appropriate.
Why?
Because there are cases in which, and I think Derriman is a case that I would point to, in which the court held that a court has inherent power to decide to appoint a separate victim representative outside the family if members of the family are seen as protecting one of the defendants, not under one of the clauses in the statute.
4403 provides for that authority. So we're just talking about who has the rights to assert a victim. I have a hard time understanding, and maybe this is because I'm a parent and try and set aside my own biases, but you're going to tell one parent you have the right to be a victim, the other parent, no, you don't get to sit in and watch the proceeding.
Sure. So in Derriman, I don't think that authority was under 4403 because 4403 provides for family members to take that role. In Derriman, they had to go to the court's inherent power to do that.
Is that in a murder
Be
case,
that
or
as
is that
it
just
may.
someone where we need a representative?
That's someone where we need a representative.
And that's to me, that's a complete different ballgame. We have to choose one person, but where we have a statute that says all of these people, it says victim means these people. To create litigation just seems like an absurdity.
Well, and I wasn't trying to bring up the necessarily the legal side of Derriman, but the factual side of Derriman. The factual side of Derriman had to do with family members who are protecting a family member. In the situation that you described, in which there are two estranged parents, it's entirely possible to imagine a situation in which the defendant is in some way related or friends of one of the two parents. And so to have both parents could be a problem in that scenario because one of the parents could be protecting a person, the defendant, and be asserting things about the litigation that are counter to the victim's interest.
Even to me, this would come up in a multitude of situations. Let's just say it's a sentencing decision. Let's say it's a death penalty case, and some family members are in favor of the death penalty. Some family members are opposed. We're going to have a hearing on, and the court's going to have to decide. I'm only going to listen to input or grant victim status to which one are you going to grant victim status to? The ones who are opposed to the death penalty, the ones who are in favor of the death penalty? Is one of those positions necessarily in the victim's interest? Why it just seems like an absurd result to me to have that type of hearing when the only thing that happens if we don't make that determination is the court just listens to everybody. The prosecutor has to listen to input from victims regardless of their views, and the prosecutor doesn't have to accept either view. It's simply give them a chance to express their view, and then that's the same obligation that the court has. Give them a chance to express their view without having to then tell them your view is better than your view, or is, and I realize the court wouldn't be saying that, but it essentially does by saying, I'm going to choose you as the victim in this case. I have a hard time squaring that with the...
And if I can respond to that example, the example that you gave about the death penalty, I think it's a good example, and I would describe it this way. These are complex decisions about who gets to take that role. I think those are best left to the trial court rather than a statute that includes everybody, because the alternative, I mean, we could either have the court pick not based on their views on the death penalty, but based on their relationship to the victim and who is closest to the victim, who knew most about what the victim would have wanted with regard to the litigation. They would choose on that basis, and that person speaks.
How is the trial
rather
court
than,
supposed to decide which of two parents gets to sit in and watch the trial?
I think that there could be
but let's say we have two parents who exactly feel the same way. They're 100% on board with having the same exact opinions. You're going to tell me a trial court under this statute should tell one of them you don't get to sit in the trial and the other one you do.
I mean, I think that is the result of the or situation, and I think, obviously
You think
that's
the legislature intended that?
I think the legislature intended there to be one voice for the victim rather than all of the voices for victims. I mean, we are dealing in this statute with an all or nothing proposition, it seems. I mean, if it's not just whether we include two parents, we also include everyone else on that list as a matter of right.
We have a separate provision, though, for a lawful representative.
Correct, 4403.
Right, and under the under subsection 12, it doesn't limit it to the lawful representative is, we don't go through that analysis. It seems to just contemplate if we don't have any other people who satisfy this definition of victim, you may need to have a lawful representative, and if someone's appointed, then they can come in and they can be a victim. But it doesn't, it seems a little bit inconsistent to have this separate provision specifying that we can come up with a lawful representative if that's the only person that gets to weigh in as a victim.
Well, lawful representative, as I read it in that series, is a person other than the other people on the list. And also in 4403, I think lawful
It
representative.
doesn't say lawful representative is either a parent, a spouse, a child, or someone who's been appointed by the court. It's just, so it seems to me that it's just contemplating if we need somebody to speak for the victim and we don't have any of these other people, and if for some reason they can't speak for the victim, then we're going to appoint a lawful representative. But that's kind of, it seems to me that's sort of the import of your reading of the provision on victim means a person who can speak for the
And I'm sorry, I think he's indicating I ran over time. Okay.
Or not the other side, the other real party and interest time.
Good morning. My name is Adam Zickerman. I represent Jason CONLEE, a real party in interest. My position is a little unique in this particular case, considering the issue here with regards to victim rights, was victim rights notified, etc. My position is coming from that of the defendant and as the court mentioned, with regards to double jeopardy. And if this court decides that victims' rights were not complied with, what happens next? My position on that is that at this point, double jeopardy attaches. And looking at
But if we were to rule that that EH should be treated as a victim, that doesn't necessarily mean that the plea has to be withdrawn, does it?
No. I think in one form of mental gymnastics, if this court remanded it back to the Superior Court and said, you need to go through the process, making sure that EH has a voice and has been contacted with regards to this particular plea. If that's the case, the court could simply go back, ask victim's representative or EH, do you agree with the plea? And let's say in that hypothetical, EH says, no, I don't agree with the plea. The court then still has the ability to accept the plea even over the victim objection. We could be right back to where we were. Now the question, though, becomes what happens? My point of view is that
Wouldn't what happen would be the victim could weigh in at sentencing?
yes, absolutely, could weigh in at sentencing, relay her position with regards to the outcome of this particular case.
And does that implicate any of your client's rights to allow the victim to weigh in on at sentencing?
If at sentencing, no. It would be a voice to be heard and one of the factors to be considered of aggravating, mitigating, and victim.
Is there anything other than, I can see where there may be at least an argument if it's victims who are refusing an interview, it could arguably implicate a defendant's rights, but that's not on that's not at issue here. There's no question about whether EH needs to be interviewed. Is there any other victims' rights here that would implicate the defendant's rights going forward in this case, or in any way in this case?
It would be hard to say on that, Judge, with regards to how that would implicate directly to my client versus the three other defendants that are out there. With regards to how it implicates.
Well, let's just focus on your client, since that's all we have before us. Is there anything, if we were to rule that EH is a victim and going forward should be treated as a victim, does it implicate? Seems to me you're suggesting that it does not implicate any of your client's rights.
With regards to that, it would simply, in my view of that, Judge, would be that EH would be allowed to have a voice at sentencing for the Superior Court to be able to listen to and affect whatever sentencing decision. If it has any further implications, there could be collateral consequences that affect the other defendants with regards to that. With looking at the issue that I think was previously raised, and I think this court actually addressed it as well, with regards to the double jeopardy issue, something that we needed to look at was, well, I have seen courts in the past, especially trial courts, say, well, because there may be a concern with one thing or another, the judge reserves acceptance of the plea. Says, I find it's a knowing, voluntary, intelligent waiver. There's a factual basis for it, but I'm going to reserve entry and acceptance of the plea until sentencing.
In your view, has there been a conditional acceptance in this case?
No. This case, my view of it, when we went through the change of plea, it was accepted and entered of record. So at that point in time, our position is that if it is undone, jeopardy attaches, which creates, well, it could create consequences for not only the victim in an adverse way, the state in an adverse way.
It's a benefit to your client.
It's an absolute benefit to my client to maintain the plea and keep going forward.
And you don't think that the language that counsel quoted from the plea agreement affects that argument?
The terms 12 and 6 within the plea agreement, Judge, with regards to that, allow that a court can say, after review of the plea, I'm not going to do it. But I've only seen that done in cases where the judge, the accepting judge, or the one we do a change of plea in front of, either on plea on demand or otherwise, says, you know what, I've reviewed this. I'm going to defer acceptance. I want to reread through this and go through the case file.
But is that typical language? The language does seem to say, even after it's been accepted, the court can change its mind.
I would agree with you, Judge, that that's what the language says. However, if we look at the overall policy, for lack of better words, that as the case proceeds from change of plea to sentencing, the judges who I've been in front of, at least, who have qualms or questions or concerns usually defer acceptance rather than to go all the way through.
I've always thought, and it's been a while since I practiced in the Superior Court, but the usual practice was that a judge would accept the plea but defer acceptance of the plea agreement. In other words, I accept your plea of guilty to whatever charge it is pursuant to the plea, and that does not mean that he's accepted the plea agreement, and the judge always has a time to reject whatever sentencing stipulations or agreements to dismiss may come as part of that plea agreement. Am I mistaken?
Judge, I've heard some judges do that. I've heard other judges in other jurisdictions accept it, enter of record. I don't know if it is common practice for one to another, but in this particular case, Judge Hatch accepted it and entered it of record.
Accepted what?
The plea offer.
He accepted the plea. Did he say, I accept the plea agreement and enter of record, or do I accept your plea and enter of record? Because it's a plea to a specific count. The agreement is, in the terms of the plea agreement, seem to have a very different understanding of that as well. So I don't even know. I don't think we have a copy of the transcript in the record. So
I have not seen one, Judge, and I would hate to avow to the court one thing or the other with regards to that, because I don't have an independent recollection of that specific language as you brought it up.
okay.
With regards to all of this, Judge, and just touching briefly on the plain reading of the statutes of OR, I think Your Honor had it right on the head, but with regards to like State versus Williams, Bilk versus State, where it's the plain reading. It's hard to read or any other way but or. In my view on the overall part of the litany of people involved as victims of, including but not limited to, essentially all this is, these are the people that can be. If the state, if there's one who is designated, they've gone through victim representative, they've used it, that person is done, it's that victim representative's responsibility to make sure everybody's informed, which would alleviate the litigation, as Your Honor mentioned before.
But this is litigation where you're not appointing someone else. I'm just saying there are two parents, there are also grandparents, and they just have wildly divergent viewpoints on whether it's the victim, on any number of issues. And are you aware of any case where there's been some kind of litigation over who gets to be the victim?
I'm not aware of any case, Judge, with regards to that. And with that, I think my time is up.
Thank you.
Or does not always mean a choice between two things, reading this provision in harmony with the Victims' Bill of Rights and in harmony with the Victims' Rights Implementation Act. This statute cannot be read in the disjunctive. Doing so eviscerates the purpose of the Victims' Bill of Rights. Arizona's case authority has already stated that purpose is to provide respect, assistance with healing of their ordeals, protection, a level of participation. And no case that I'm aware of has ever limited that, with the exception of Allen versus Sanders, which this court ruled that a step-sister is not a victim. Other than that, I'm not aware of any case that the court has actually limited a victim. The statute and the constitutional provisions themselves already expressly exclude who cannot assert rights, and that is a person in custody for an offense or the accused. The absurd results would lead to hearings that the Supreme Court warned of in Knapp versus Martone. It would lead to instances where the example you provided, where there are two separate parents and only one can assert rights, defense counsel may not be able to get discovery or an interview with the one who can assert rights, but they could certainly get it from the other parent who couldn't assert rights if this statute were to be read in the disjunctive. One point I wanted to address earlier, a common theme throughout the state's response is that EH seems to need permission of the trial court or some stipulation of the parties to assert rights, and that is not the case. Those rights are bestowed upon her when her brother was murdered and when there is an arrest or formal charging. She has already filed a notice of appearance, granted later in the proceedings, but her notice of appearance is her assertion of rights.
One concern I have is that the idea that, especially when it goes to what the second degree of consanguinity or whatever the statute says,
Yes.
how is a prosecutor's office supposed to comply with the notice provisions in that situation? How are they supposed to track down, or are they obligated to track down everybody? What is that second degree? Would that be cousins?
The statute reads a consanguinity relation or affinity relation to the second degree. An affinity relation is a marriage relation. Consanguinity is a blood relative. The affirmative duty is on the prosecutor's office to assert rights. How each prosecuting agency tracks down.
Is your office familiar with how other counties in Arizona deal with this?
Yes, Your Honor. As far as the procedure for tracking down victims, I don't want to say I'm familiar with that, but what I am familiar with is how other counties and Arizona Voice for Crime Victims, we do take cases all over the state. Every other county that I've been in, currently cases in 8 or 9 different counties, I've never seen another county interpret this statute in the disjunctive or in a way that
But setting aside the
excludes.
interpretation, the question, I think, is, do they send out a notice to every person that fits, every cousin, or how do you accomplish that? And if you don't, have victim rights not been complied with, do you have to track down every grandparent who lives outside the country? Is that possible? Is that done?
Yeah, and I'm afraid I don't know the answer to that. I'm certainly happy to talk with various agencies that I work with. I would imagine that somewhere in the law enforcement report that's how they determine who the next of kin or the victims are. Whether or not it's a violation to not track everyone down is, I don't know the answer to that question. But again, I'm happy to find out the procedure that each county uses. My experience in Maricopa County is that the victims I've represented generally have gotten a letter of some sort advising them of their rights.
How come your client never attempted to substitute herself for the representative that's been appointed?
Of course, Your Honor, and I don't think she has to substitute herself for the representative. My understanding is that the representative, Ms. Vaquez, was appointed for the actual homicide victim, JH. My client, these rights are hers and they belong to her individually. These rights are hers to refuse interviews, to be present. I don't think she has to step in and say, I'm asserting rights on behalf of JH. She can step in and say, I'm asserting rights.
And she may have a different point of view than she knows the person who's murdered, different points of view than she has, and presumably she's not required to say, well, I know this is what the victim wanted. You're suggesting that she has the right to her own views.
Of course, Your Honor, she does. As a surviving family member, I see that I'm out of time. May I finish
You
my
can finish your sentence, yes.
My sentence. As a
Thought, I'm sorry.
My thought, thank you. As a surviving family member of a murder victim, she has those rights, and that's what the Victims' Bill of Rights and the Implementation Act recognizes, is that there is a traumatic effect on folks who are left behind and that they deserve protection and rights. With that, I will wrap up and thank you, the court, for hearing oral argument today, and I would ask that you issue an opinion that 13440119 is not to be read in the disjunctive and not to exclude possible victims. Thank you.
Thank all of you for your briefs and presentations here today. We will take this matter under advisement and issue a decision in due course. We are now at recess. Actually, we're now adjourned, sorry.